পড়ে যায় তো। Yes, please.
Yeah, your lordship. So with the consent of the other side, back to item number 6, lordship. So here Mr. Learned Counsel as Bhattakur also is appearing. He is in
Bereavement.
Yes, lordship. After the vacation.
As prayed for, on behalf of Mr. S. Bhattakur, learned counsel appearing for the petitioner who is in bereavement, relist after 3 weeks on a date to be fixed by the registry.
Different.
Any interim is there?
I'm-
Interim is there?
Yeah, please, your lordship. Lordship, we do consider other side at examination item number 19, my lord.
Yes,
And we are appearing for the first time for respondent number 2, 3, and 4, my lord. My senior, Mr. G.N. Sahewala, and myself.
you're appearing for,
2, 3, and 4.
have you taken consent from the other side?
Lordship.
When do you want it?
After 4 weeks, ma'am.
Paid for by Mr. M.
Sahewala.
Sahewala, learned counsel appearing for the respondent number
2, 3, and 4.
2, 3, and 4 with consent from the other side, relist after 3 weeks on a date to be fixed by the registry.
Deeply.
May I please, Lordship? With the consent of the petitioner, I beg to mention item number 8, Your Lordship, for the adjournment today.
Item 8,
Yes, Your Lordship.
you
After
are
the
for the
petitioner-
petitioner,
I'm for the respondent number 2, Your Lordship.
as prayed for by Mr.
P. Boro.
P.
Boro.
Boro,
Yes, sir.
learned counsel appearing for the respondent number 2.
2, yes.
With consent from the other side, relist after 3 weeks on a date to be fixed by the registry.
Highly obliged.
Yeah, please, your lordship. I beg to mention item number 33. Lordship, I am praying for an adjournment.
You are for,
Petitioner.
as prayed for by Mr.
Yes, Bolhuya.
S.
Bolhuya.
Barbhuya, learned counsel for the petitioner, relist after 3 weeks on a date to be fixed by the registry. Yes,
That please, your lordship. Lordship, item number 48 of supply list, lordship. But I am for the petitioner, but by order, this case is being listed, lordship, but I do not know. But today, my lordship, and I have some personal difficulties, lordship.
you are for the petitioner.
Petitioner, lordship.
As prayed for by Mr.
F.
F. Hawk, learned counsel appearing for the petitioner, relist after 3 weeks on a date to be fixed by the registry.
Maybe, lordship. Lordship, I beg to mention item number 15, lordship. Lordship,
Item
matter
number
15, 1-5.
15.
Yes, lordship.
Yes.
Lordship, matter will become infectious, lordship.
Infractious.
Yeah, lordship. Kindly withdraw the matter.
15. File to our swap kiba.
16, not 50, only 15.
15 is along with 16.
Not, lordship, only 15. Therefore.
Then you wait. Let the matter be called. Who is appearing in item number 16?
Okay, lordship.
Who is appearing in 16? Counsel for 16 is here. Mr. Counsel, because it is a tagged matter, so you wait.
Lordship,
All right?
lordship.
Yes.
Motion matter, my lord, for tomorrow.
Senior bench asini. Before the appropriate bench. Yes.
On motion, item number 1.
It would take for anybody from compared with their bias or
May I please, your lordship.
transfer.
Lordship. And lordship, the petitioner is residing in Coachbihar, West Bengal, lordship. And the respondent number 2 is lordship, and he is residing at Boyagaon. And divorce petition has been filed by the respondent number 2.
Notice, Mr. D.P. Goswami accepts notice on behalf of 1 registered post in respect of 2 within 3 days from today. Returnable 3 weeks, list after 3 weeks and a date to be fixed by the
Till
registry.
then, till.
Nothing, it's a transfer. Yes.
Obliged, lordship.
Number 2.
May it please, my lord, same prayer. Notice no issues, my lord, to sole respondent.
Notice returnable 3 weeks, steps by registered post AD, list after 3 weeks.
Also, if interim prayer may be considered under next step, my lord.
Automatically it will be.
Not.
Yes.
On admission, item number 3.
My lord, during this case, respondent.
Transfer petition.
Yes, my lord. My lord, I am pressing for interim order, my lord, because our case is fixed on 4/7/2025. It is. my lord,
Interim orders are not given because matters are fixed on such and such date. You have to first make out a case for the interim order. Yes, what is the ground for transfer? What is,
My lord, I have taken some ground and it is stated in para
what are the grounds?
17, 18, my lord, some allegation against the presiding officer and my lord, the public prosecutor.
What is the stage of the proceedings?
It's my lord, DWs. Evidence of the DW.
Evidence.
Yes, my lord. This,
Where are the grounds stated?
Lordship may kindly see para 17 onwards. my
Mr.
lord.
Talukdar, you are appearing.
I'm appearing for the informant.
You have filed your objection.
Objection, I filed a colloquy. It is in the fag end of the trial. Now it's defense evidence is going on.
Yes.
Prosecution is closed and it is delaying the matter. I'll show one order from this, Honorable High Court also. First, let him submit.
Yes, grounds.
Lordship may kindly see para 17 onwards.
Around?
17, my lord. Page 14 of my petition, my lord.
When did you file this?
My lord, this was. filed-
21/10/2024.
Yeah.
Yes, para.
Para 17 onwards, my lord.
Yes, read.
Yes, madam. That the petitioner beg to state that petitioners are facing trial under charges under sections 302, 427, 34 IPC and had a checkered history since 2011. Now, during the trial before the present presiding officer, at the influence of the victim, the public prosecutor and the presiding officer are determined to convict the petitioners as early as possible, and hence the petitioner found that there is a lack of fair trial in the court of district and session judge Hujai. The petitioner noticed from the activities of the public prosecutor as well as presiding officer, because they always favor the prosecution case story, and by rejecting the petition openly discuss about how to convict the petitioner.
If such grounds are taken in every cases wherever the defense feels that they may not get a favorable judgment, they will start making allegations. One of your ground is that the early disposal, that is the need of the hour. Repeatedly, the Apex Court is emphasizing that the trial should be concluded at an early stage. Yes, you should be happy that the trial is getting early, and if any order you are aggrieved, you can always file an appeal. If any of the order that has been passed, if any prejudices have been given to you, you could have come before this court. What kind of a ground is this in para 17, Mr. Counsel?
Next, madam.
It's so vague.
That the counsel for the accused petitioners and when submitted any genuine petition such as mentioning to criminal petition was pending before the Honorable High Court, and the Honorable High Court observed for interim order on returnable date and requested the trial court to adjourn the matter, but same were rejected on the objection of the victim as well as public prosecutor, and compel the petitioner time again.
That is not sufficient. That is also not sufficient because the trial court, there is no order for the trial court to do something. It was considered. The trial court have considered and rejected. Now, if you are aggrieved by that order, you could have always come before this court.
Yes, we approached my lord
So,
thereafter.
where have you challenged that particular order? Where the adjournment was not given? Is that order challenged?
Yes, my lord, and this honorable.
Order has challenged. Mr.
Yes.
Talukdar, that order has been
Yes.
challenged.
And
Next
this honorable
page,
court also
page
granted
88 also.
opportunity.
Lecture,
Next at 20, page 88 will also can see.
lecture 20,
3824 of this honorable court.
lecture page,
Page 88.
180.
Double it. Rather, he is delaying the matter. That you'll also find from the order.
Yes, my lord, I approached my lord, and this honorable court has also granted opportunity, my lord. My
That you'll also
request is
can
my
see.
lord,
The para 3 will also
fair
see.
trial, my lord.
Page 88. The case of the petitioner in Nasser is that he has been facing trial before the court below. And after closure of hearing the prosecution witness, he took 3 years time to examine defense witness. So he is rather delaying the matter. The learned trial court felt that sufficient time was granted to the petitioner for examining defense. Therefore, hearing for examining defense witness was closed. I have considered the submission of the made learned counsel. This court is of the opinion learned trial court has correctly had the said decision, but the petitioner shall be given one single opportunity to examine 3 defense witness. Therefore, the impugn order is to that effect is set aside.
And that another date was given.
Given, it was given.
Yes, my
And
lord.
Now
that
it's
date,
in-
what happened?
It now is in defense evidence lordship. In one, he was examined as DW2, thereafter he fell ill.
Mr.
So-
Counsel, either I admit and reject your interim and post the matter for hearing, or I dismiss your petition today. Which option do you want?
Up to him, up to him.
I am not granting you interim.
Next
I am
day
making
you
it very clear. This is not that. Absolutely.
Fix the instruction, my lordship may fix another.
Heard, Mr. Jiuddin, learned counsel appearing for the petitioner. Also heard Mr. D. Talukdar, learned counsel appearing for respondent number 3, and Mr. A. H. Sarkar, learned counsel appearing for respondent number 2, and Mr. Who's appearing for Mr. Sharma? You're appearing for the PP? Mr. B. Sharma, learned APP for the state respondent. Stop. By way of this transfer petition, the petitioner is seeking transfer of session case T1 stroke 05, T1 to be bracketed debug 05 stroke 2018 pending before session judge Hosai to any nearest district for fair trial. Stop. Admit no formal notice as parties are represented.
Record has already come.
It appears no records. What records?
Scan was called.
Has it arrived?
That I don't know.
And copy? It appears that the scan copy call for has already been arrived. Mr. Jiuddin, in support of the interim prayer, drew the attention of this court to paragraph
17 onwards.
17, 18, 19 and 20, my lordship.
paragraph 17 to
20.
20 of the petition. Paragraph so-and-so to so-and-so is quoted hereunder. Reading of the aforesaid paragraph, the grounds urged for transfer does not inspire the confidence of this court. That being so, interim prayer sought has been rejected. Pose the matter for hearing. Yes. When? Hearing. Mr. Uddin,
After we will take instruction.
when do you want hearing?
Well,
September 2025.
Well, before-
Yes.
Maybe before, otherwise my petition will be.
Please call the next matter.
May I please your lordship? Lordship, pass over the matter for.
I cannot hear you, ma'am.
Pass over the matter for time
What?
being hold.
Me, please, your lordship.
Yes.
But this matter relates to the custody of my phone and two SIM cards, my lord, which were seized in August 2024, my lord. It has been around 10 months since the seizure. Now, my lord, one.
Not returned.
No, my lord.
The report was called for, okay, FSR report not received, that's why the report was not prepared. By the.
You place the report positively on the reopening. Cell phone and
Two SIM cards, man.
SIM card. So whatever details are there, you can always get it. You don't need the cell phone and the SIM card for that. SIM card details, you can obviously get it, Mr. Counsel, isn't it? So you please instruct your counsel and check the jurisdictional police. Mr. MP Goswami, right? Sorry, DP Goswami, learned APP for the state assures that the report as called for shall be positively placed before this court by the next date of listing. List on such and such date.
Number 7.
Yes,
Matter, your lordship.
yes.
Also, this is application under section 482 CRPC, my lord, for quashing of entire procedure of, my lord, special POCSO case number
Where is
67.
the FIR?
My lord, page 16 is the FIR, my lord.
Mr. Mahajan, you're appearing for the informant.
Am I cascading?
Page,
Page 16, my lord, FIR.
yes,
May I read, my lord?
please.
I'd like to inform you that myself, Rahman Ali Nazrul Haq, son of Nazrul Haq, of near AG Colony Gate number 1, Helipad, Boshista, Guwahati. That, sir, I have noticed a fact that a married couple, namely Parvina Khatun and Shafiqul Islam, is residing in the rented house of Nila Prasad, son of Rama Prasad, resident of near AG Gate number 1, near Kali Mandir, Helipad, Boshista for the last 3 months. Sir, as per my information, her father and father of her husband had forcefully organized a marriage at her husband's village in the Senimeri under Borpeta by local Kaji of the said village. Further, I have also come to know that the girl Parvina Khatun was aged about 17 years old at the time of marriage, and she was a victim of marriage by inducement. This is the FIR, my lord.
Let's give in the FIR.
This person is not belongs to the victim family, not known by the victim family.
Victim statement is there.
Yes, my lord. I have annexed the victim statement is the page, my lord. 31, my lord. Page 31 is the 164 statement, my lord.
Yeah.
This I have, may I read, my lord?
Yes, please.
At present, I am aged about 19 years, 1 month, 15 days. I got married with my husband according to the social norm about 7 months ago. We both got married with the consent of our family members. At the time of marriage, I was major. At present, I am 7 months pregnant.
What is there then?
My lord.
Last occasion, my lord, since there was no affidavit from the victim, my lord, this joint petition, my lord.
Yes, affidavit I have filed.
They have Ladakh court directed them to file an affidavit. They have filed an affidavit, my lord.
Where is that affidavit?
Affidavit, page 38, my lord, onwards.
In that affidavit, my lord, they have said that they have a child also, my lord.
Yes, my lord. I have
annexed
annexed
the birth certificate.
birth certificate, page 41, my lord.
Additional affidavit?
Yes, my lord.
Yes, paragraphs?
My lord, paragraph 2A, my lord.
Yes, yes. The victim is also given an affidavit before this court.
Yes.
Then I think no, we can
My lord.
close it.
My lord.
Normally, my lord.
Victim is living happily.
Yes.
She's a major.
My-
Now, to continue with this, it will hamper their marital life.
My-
That certainly can't be the object of the POCSO Act. Mr.
AK Azad.
Heard Mr. A.K. Ajat, learned counsel appearing for the petitioner. Also heard Mr. D.P. Goswami, learned APP for the state respondent, and Mr. N. Mahajan, learned amicus curiae for respondent number 2, stroke informant. Informant, right? So you are that third party.
I do not have any connection with the family.
Oh, I am just otherwise saying
Yes,
the informant. Because this being a POCSO case, perhaps notice should have actually gone to the victim, but now we have the victim's affidavit.
Yes.
Victim here as a petitioner number 2.
It's a joint petition.
Yes.
By way of this joint petition, the petitioners are seeking quashing of FIR charge sheet Vide number 99/2023 dated 5/4/2023, registered under section 3762 IPC, read with section 6 of POCSO Act, read with section 9 of the Prohibition of Child Marriage Act, and subsequent proceedings of the session special case number 67 of 2023, arising out of Bokhisto PS case number 61 of 2023, pending in the Court of Additional District and Session Judge Special POCSO Kamrup M. The brief facts of the case is that on the basis of a complaint lodged by the respondent number 2 to the effect that a married couple, namely petitioner number 1 and petitioner number 2, is residing in rented house, which is namely Sofiqul Islam and victim X, within bracket petitioner number 1 and 2, is residing in the rented house at Bokhisto, Guwahati for the last 3 months, and as per his information, their parents forcefully organized a marriage at her husband's village in Senimari under Borpeta by a local Kaji of the said village. Accordingly, a case was registered under section 3762 IPC. It was registered as stated above, liquidity. Was registered as stated above. Charge sheet was filed, right?
Upon page 21, madam.
Upon completion of investigation, charge sheet was also filed. And thereafter,
I want to throw something, page 21, my lord.
page 21.
But as per the charge sheet, my lord, she was below 18 at the time of marriage, my lord. But as per the affidavit, my lord, the date of her marriage, my lord, she was more than 18, my lord.
All right.
Page 21, my lord.
Charge sheet was submitted, whereafter trial commenced. Stop. The petitioners, being husband and wife, and still continuing with their conjugal life peacefully, the present criminal petition has been filed. Stop. Mr. Ajad so-and-so learned counsel for the petitioner submits that the victim girl has attained the age of marriage, has attained major, it says, no? Has attained major at the time of marriage, and accordingly no case under the POCSO Act as alleged is made out. He further submits that they both have voluntarily married each other as per the rituals and are also living peacefully in their conjugal life. He further submits that the victim girl has also filed an additional affidavit before this court to depose that she was major at the time of marriage, and that out of the wedlock, a baby girl has also been delivered. Stop. By contra, Mr. N. Mahajan, Leonard APP for the state respondent fairly submits that, amicus curiae fairly submits that considering that the victim in her affidavit, which was filed pursuant to the order dated 16/5/2025 passed by this court, has averred that she was major at the time of marriage and that she has voluntarily married the petitioner number 1, and out of the wedlock a baby girl has also been born and she is peacefully living with him, perhaps further continuation of the criminal proceeding would be detrimental to their conjugal life. Correct? To the married life. Stop. Similarly, Mr. DP Goswami, right? DP Goswami, APP has also submits that further in view of the facts for the continuation of further proceedings would be prejudicial and detrimental to the couple. Stop. Heard, perused. Now, apt to reproduce the relevant paragraphs of the additional affidavit filed by the victim stroke petitioner number 2 as per the direction of this court passed on 16/5/2025. Stop. Quote unquote paragraph 2. ABC asadat. D leke. Quote koribe. Reading of the aforesaid paragraph, it appears that the petitioner number 2 stroke victim and the petitioner number 1 got married on 2/7/2022, and their marriage was solemnized as per Islamic rites and rituals in presence of both side parents stroke guardians. It further appears that the date of birth of the petitioner number 2 on the day of marriage was about 18 years, 6 months, 1 day. It further appears that since the date of marriage, I-1/1/2024, no, not that. It further appears that since the date of marriage till date, they both are continuing with their conjugal life peacefully, and out of their said wedlock on 31/2/2025, they were blessed with a baby girl named Safrin Ahmed. No, name, don't give the name, baby girl, stop. It further appears that the birth certificate of the aforesaid child is also enclosed as Annexure A to the additional affidavit. It further appears that the petitioner number 2 stroke victim has categorically denied that there was categorically denied the allegation of forceful marriage or marriage by inducement, and that at the time of marriage she was not she was a minor, as alleged by the informant who is stated not to belong to their family or known to them. Stop. Considering the aforesaid allegations, considering the aforesaid affidavit, considering the averments made in the aforesaid affidavit, this court is of the firm view that further continuation of the proceeding against the petitioner number 1 would be detrimental and prejudicial to the interest of the petitioner number 1 and 2 as a married couple, and keeping the interest of the victim petitioner number 2 in mind, this court deems appropriate to allow this criminal petition. Stop. Accordingly, page 12 or 2 pajama. Accordingly, the FIR charge sheet VDA number 99/2023 dated 5/4/2023 and subsequent proceeding of the session special case number 67/2023 arising out of Bokhista PS case number 61/2023, including orders dated 2/5/2024 passed in petition number 500 of 2024 in respect of discharge of the petitioner. I think that is not required. Don't say including, are hereby set aside and quashed. Anything else required? Disposed of.
Must suffice.
Domestic violence.
May I please, Your Lord?
Yes.
I am appearing as legal aid counsel. My lord, I am, revision petition is for requesting and setting aside the order passed by learned decision. This is that my lord, Kambam Metro. My lord, kindly admit this appeal, and my humble submission is this, my lord. Only 3,000 rupees granted by the lower court, but my lord, already they have filed another petition to return back the money. And huge amount is pending, my lord. So kindly stay the order of the lower court, my lord. Otherwise, it's not possible on her part to return the money, my lord.
1 second. Hey, কোনখন পেন চলি আছে শব্দটো দিগদাৰ পাই আছো দেই ভলিউমটো কথা ক'বা শুনাত দিগদাৰ হৈ আছে মানে No one who is appearing for the other side?
My lord, today is for admission in say government of 9 order 9 number 9.
What is the status of the service? Yes, notice is not issued.
No, my lord. No, already I have issued the notice, my lord. Uniform from
Miss
my
Counsel, you,
state
no doubt you are a legal aid counsel, but at least have a look at the order sheet before you appear before the court, Miss Counsel. This is the basic, what is expected out of counsel. Notice is not issued, nothing is there. Have a look at it. Released after 1 week on a date to be fixed by the registry.
Yep.
Next.
Yeah, Beach.
POCSO. Yes, informant has been served. First time.
Today is the first.
What is the IA for?
I for suspension of the judge.
Then notice has to go. Notice, Mr. Goswami accepts notice on behalf of R. It is R1 or R2,
POCSO has already been acquitted. You know,
whatever.
only
There is one.
R1, notice in respect of R2 as per Deepak Nayak so and so, list after 3 weeks on a date to be fixed by the registry. issue notice in both the
Appeal.
criminal appeal as well as the I.
Applicant
Yes.
is in court bail, my lord.
Next.
Serious case. Last.
Well, the FIR was lodged against IPL betting, but against betting in IPL. I'm not naming the FIR, I'm not for that person.
You
How
are
much-
seeking quashing of the FIR.
No, I am seeking the Jimma stroke custody.
What has
of the-
been taken custody?
Amounting to, cash amounting to 62 lakhs 80,000.
Cash.
Cash. And I have given an iPhone. And I have given the explanation at page 6, paragraph 4. I have all the documents, audited balance sheet and all of
Where
it.
is the order rejecting the JIMA
Yes.
petition?
Your lordship will find page 103 is the first, the rejection of the prayer for Jimma of the mobile phone is reflected at page 103.
Yes.
Then at page 104, your lordship will find the background of the case.
Yes.
Then your lordship will see the 109 prayer for custody of cash, seized cash amount in petition number 109. Basically, Malad, the gist is that investigation is pending. That's why your lordship will find the operative portion at page 113. And FIR is of 19/4/2024.
1 second, I'm just reading this.
Yes.
What is this? Both the prayers for releasing the seized cash amount is similar in nature. What does that mean in page 110?
There are 3 accused, 2 accused, it is referring to them. My cash amount and all explanation you'll also will find at paragraph 4 at page 6. And I've annexed those documents, madam.
According to you, you are not involved.
No, and I have got my explanation for my cash that your lordship will kindly see at paragraph
Where
4.
is the ground of saying on what ground it has been rejected as far as you are concerned? Where do I find that part?
113.
104.
Huh?
113, my lord, your lordship.
113. Be that as it may.
Yes. It says unaccounted. I have my explanation, madam.
See, the amount is also huge.
Yes, ma'am. But I have an explanation. I am a
But that,
industrialist.
that is
No, more, your lordship will.
a matter of trial, right, Mr.
No,
Kaur?
your lordship will kindly see my.
Because that decision of the Apex Court, which deals with the seized items, those are of different
No, my lord. Now-
kind of goods, right? If I'm not wrong, correct me,
Yes.
because
I'll-
generally those goods
Yes.
perishable or vehicles, because it might get
My-
destroyed.
Relying on that Sundarbhai's case.
Sundarbhai,
now
correct.
The trend has changed because nobody wants to keep that case in the custody
For
of the.
cash, what is the decision?
Yes, my lord. I'll come to that, but prior to that, your lordship will kindly see paragraph 4 at page 6.
Yes.
Now your lordship.
Only ground is unaccounted, right?
Your
That is the
lordship-
ground
yes,
of rejection.
Your lordship will kindly see page 4, paragraph 4 at page 6. I have given those documents, my lord, but your lordship.
Paragraph 4, page
6.
6.
Now your lordship will see.
And 4 at page 6. Okay, okay.
Yes.
Yes.
Your lordship will see 62 lakhs 80,000 and 890. Now your lordship will see cash balance of Nikhil Agarwala as on 31/3 2024 as per audited balance.
Report has come.
Report has not come.
They have sent.
Entire case there.
Your lordship will see.
So then what is to be done?
A specific report may be called for.
So, I can have it on the first day of the reopening. You obtain the report then. Without the report, it will be difficult.
Your lordship will kindly.
This court is not going to go into the entire case records and look for the reasons now.
And Melody, in that ballot, city ballot, it is not clear whether that case or mobile phone is.
Just get a specific report, because if, in fact, you see, by keeping so much of cash is also you are taking a risk. So if that, you can obviously return it with all the conditions and the guarantees, there is nothing wrong because they have already investigated. Now, what more has to be investigated out of the cash?
Your lordship will see.
Isn't it?
Nowadays,
The core, I'm keeping it on the first day of, would you be here on the first day or second day?
your lordship will kindly see the last one.
Yes, I've seen. That's why I asked for the report 18/6/25.
Let it be on my lord 16.
16, await report as called for earlier by this court by order 18/6/2025. Mr. B. Sharma, alert APP for the states assures that the aforesaid report as called earlier shall be positively placed before this court on the next date of listing. Stop. Before that, you say reporter Ragatrona, but it appears that though report was called for earlier by this court by order dated 18/6/2025, however, instead of producing the report before this court, the case records, the entire case records have been sent, from which it cannot be ascertained as whether
the Jimma of the particular amount and my lord.
whether the Jimma of the cash amount, cash recovered in question is essential or not? Is essential or not?
Well, nowadays it has changed. Well, the condition that are normally imposed, and there's a very prominent judgment of the Odisha High Court. They have imposed a conditions like, say, you have to keep high resolution color photographs should be taken for permanent record.
Mr. Kaur, I have understood that we can only consider after giving them a chance. That is why I'm giving them a last chance. If on the reopening they don't come up, you produce that judgment, we will give you the order.
Yes.
But a last chance I'm giving. Then you require assurance, so and so. Accordingly, in view of the aforesaid assurance, relist on such and such date to deduct.
16.
It is needless to be clarified that on that date, if the report as called for is not placed before this court shall consider consider disposal of the criminal petition on the in accordance with law.
We are obliged, sir.
Yes, Mr. Saikia, which matter are you waiting for?
Item 14, Lord.
Next matter.
The 11, if I'm not wrong.
Because since you must have left all your matters there and is waiting here, so I thought, let me check. All right.
Item 12.
May I please, Your Lordship. Lordship, this is an application under section 520 of BNSS. This is an application under section 528 of BNSS, Lordship.
Yes.
For passing of the order dated.
Which order?
Lordship, page 23.
Yes.
8/11/24 passed by the learned judicial magistrate first class.
Diligence or summons?
Lordship, cognizance order. Here, Lordship, cognizance has been taken under section.
230, 74, 3512, 1152.
Yes, Lordship. Lordship, where 230 deals with the evidence, Lordship. Lordship, FIR is page number 12, Lordship. Lordship, may I read it?
Objection was filed.
Yes, Lordship.
Yes, FIR is at page.
Page 12, Lordship.
Note
Type copy is it at Lordship?
page 12.
Lordship, type copy is at page 11.
Yes,
So may I read it?
please.
মহোদয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি ইংৰাজী 13/9/2024 তাৰিখে আবেদনকাৰীয়ে শ্ৰী শ্ৰী পুনৰী থান আৰু ভাগৱত পাঠ ব্যাখ্যা অনুষ্ঠান আবেদনকাৰীয়ে ৰাইজৰ বাবে অন্ন যোগান
ধৰিছিলো। দিনৰ ভাগত ভালদৰে শাৰীৰিক আৰু মানসিক কষ্টৰে পাৰ কৰিলো। দুখৰ বিষয় এই যে ৰাতিৰ অনুষ্ঠান অপৰপক্ষই মোক অশ্লীল বাক্য প্ৰয়োগ কৰি মোৰ গাত হাত তোলে আৰু গতিয়াই পেলাই দিয়ে আৰু মোৰ দুই পুত্ৰক প্ৰাণে মৰাৰ ভাবুকি দিয়ে মাৰপিট কৰে। So this is the fact. After then FIR is
The allegation is that used obscene language,
yes,
laid hands on me and pushed me away.
yes, Lordship.
These are three allegations.
Yes.
So what are the sections?
Sections registered under section 230, 74, 351, 2B and 115, Lordship.
So IPC,
BNS.
BNS.
BNS. How is 230 applicable?
Lordship.
On the face of it, 230 is not applicable. Next is 74.
74, Lordship.
Others are applicable.
This
Lordship.
is
Huh?
Others are applicable, Lordship.
Let's see.
74.
74.
What is
Assault or
74?
Use of criminal force to women with intent to outrage or modesty, Lordship. Your punishment is extended to 5 years, Lordship.
Yes, then 74 and then
Then Lordship 351 2.
3.
351 2. The Lordship 351 says criminal intimidation, Lordship.
1 second. 351.
351. Yes.
351 2.
Three 351-2.
Yes, Lordship.
Yes.
352 says whoever commits the offense of criminal intimidation shall be punished with imprisonment of either description for a term which may extend to 2 years or with fine.
Here also there is a threat.
That's it.
Threatened to kill my 2 sons.
351 2 will be applicable.
The allegation is there. Now, whether these allegations are true, not true, this court at this stage is not going to go into it.
Lordship,
It's a matter of trial.
yes, Lordship, matter of trial, but
So
section-
only thing that this court has to see whether on the face of the FIR, if any allegation is made out. Apparently allegations are made out, ingredients are there.
yes, Lordship, but
Yes.
section 230, Lordship, this is deal with.
230, all right. I can, in fact, Mr. Counsel is also fairly saying that 230 is not applicable. 230, we will drop it. But what about the others? They are there.
Others, we are ready to file those sections.
Huh?
We are ready to file.
You're ready to file?
Yes.
Face trial.
Yes.
All right, then I'll dispose it of.
Then Lordship, we just want to delete this section 230.
230 will be deleted.
Lordship.
Heard Mr.
Yes, Purva.
H.
Purva.
Barwa, learned counsel appearing for the petitioner. Stop. Also heard Mr.
P. Bordelais, Lordship.
E.
Bordelais, Lordship.
Bordoloi, learned counsel appearing for respondent number
2, Lordship.
2 and Mr. B. Sharma, learned APP for the state respondent. Stop. By way of this quashing petition, comma, the petitioner is seeking quashing of
Page 9, Lordship.
of the impugned order dated 18/11/2024 passed by the learned judicial magistrate first class Lakhimpur, North Lakhimpur in PRC case number 631/2024, whereby cognizance was taken against the accused petitioner under section 230, 74, 3512, 1152 of BNS 2023. Stop. Inter alia, inter alia portion. The brief facts of the case is that On 14/9/2024, the respondent number 2 had lodged an FIR alleging inter alia that on 13/9/2024 at night, the accused petitioner assaulted the respondent number 2 assaulted her and abused her by using obscene language and also threatened to kill her 2 sons. Stop. Accordingly, a case was registered against the accused petitioner. Upon completion of investigation, charge sheet VD number 41/2024, dated 26/9/2024, was submitted before the jurisdictional chief judicial magistrate. Thereafter, the learned CJM Lakhimpur VD order dated 8/11/2024 transferred the case to the Court of Learned JMFC Lakhimpur, North Lakhimpur for disposal. It appears, thereafter, on 8/11/2024 itself, the learned JMFC Lakhimpur, North Lakhimpur took cognizance against the accused petitioner under sections 230, 74, 3512, 1152 of BNS 2023 and accordingly issued summons against the petitioner by fixing the date of appearance on 10/12/2024. Aggrieved by the aforesaid cognizance, the present criminal petition has been filed. Stop. Mr. Borwa, learned counsel for the petitioner submits that no ingredients of section 230 prima facie being made out on the body of the FIR and the materials available on record, the impugned cognizance by the learned jurisdictional magistrate is bad in law. He, however, fairly concedes that as per the remaining sections under which cognizance has been taken, the accused petitioner is ready and willing to face trial. Stop. Mr. So-and-so, on per contra, Mr. No, don't say per contra. Similarly, Mr. P. Bordoloi, learned counsel appearing for the informant, submits that a prima facie reading of the FIR disclose no offense under section 230 of BNS 2023. Stop. Mr. So-and-so APP also concedes to the aforesaid. Heard, perused, apt to reproduce the FIR, page.
Page 11, FIR page.
That vernacular was that page?
Page 4.
11, right?
12.
11. Apt to reproduce the FIR dated so-and-so, which reads as hereunder, A to A, page 11. Reading of the aforesaid FIR, it appears that upon the allegations made therein, as regards that on 13/9/2024, when the informant was providing food for the public at Bhagavat recital held in the premises of
Sri Fuloni Than.
Sri Fuloni Than,
Yes, sir.
The accused petitioner during the night of the aforesaid event used obscene language towards her, laid hands on her and pushed her away, and also threatened to kill her 2 sons as well as assaulted them. Stop. Apt to reproduce section 230 of BNS, which reads as hereunder. Reading of the aforesaid allegations made in the FIR, it is evident that the ingredients to attract section 230 of BNS so-and-so is not made out. Accordingly, the impugned cognizance by order dated so and so. As far as section 230 of so and so is concerned, is bad in law. Accordingly, the same is set aside and quashed. However, the trial shall continue in respect of the remaining charges disposed of.
Obliged, Lords.
Yes, case diary, report. What does the report say?
11 prior, may I interrupt you?
Vehicle?
Vehicle. The last 11 prior, the investigation is, the case is almost completed, as the seized vehicle is no more required for the purpose of the
It can be
investigation.
returned. So this court can direct, or this court has to send it back for disposal. What is, you have that order of the apex court?
No, only the report from IO, Lords.
All right. Heard, Mr.
Yeah, Ali.
A. Ali, learned counsel for the petitioner, stop. Also heard Mr. DP Goswami, right?
Okay.
Learned APP for the state respondent. By way of this petition under Section 497 of BNSS 2023, the petitioner is seeking JIMA of the seized article of one Swift Desire vehicle bearing registration number AR 15-3692 seized in terms of Junai PS case number 25/2025 registered under Section 3402/240/318/318/4/61 BNS. It costs title. The brief facts of the case is that paragraph 1, Aru Tutbaba, huh? Which is the order by which the JIMA was not rejected? Earlier rejected? Where is that order? Not given here.
No, madam.
Why? It appears that in connection with the aforesaid case, the aforesaid vehicle was no, let's not go back. Since the aforesaid vehicle, after registration of the FIR, was seized, the present petition has been filed. Mr. So-and-so submits that he is the purchaser of the vehicle and the owner. He is the purchaser and the owner of the vehicle and has not committed any offense as alleged in the FIR. Stop. Heard, perused, the grounds of release of the vehicle as averred in the application reads as under paragraph 3, 4, 3 and 4. The report called as called by this court is placed before this court by Mr. DP Goswami, learned APP for the state respondent. A perusal of the aforesaid report indicates that that the investigation of the case is almost completed and the seized vehicle is no more required for the purpose of investigation. It further appears that the investigating officer has clearly stated in the report that the permission of JIMA of the seized vehicle may be ordered if the court deems fit and proper. That being so, the application is allowed. Accordingly, it is ordered that the JIMA of the vehicle bearing registration number AR 153692 seized in terms of so and so to Prerot Sabha is to be handed over by taking necessary conditions disposed of.
This is a petition.
1 second, Mr. Second. Yes, please.
This is a petition under section 520 NS of washing of the third affair.
Third FIR.
Third affair. So if and on 13th June, Lordship would like to see that order, a detailed order after a lengthy hearing.
Yes.
The Honorable Court was pleased to give some interim relief, but one observation at paragraph 12. May I read this paragraph?
Yes, please.
I find force in the argument.
Just
of-
1 second. Let me reach paragraph 12.
12.
It's a long order.
Long order, very long, and it after a detailed hearing.
Yes, I have
I find force in the argument of the learned senior.
paragraph 12.
I find force.
It
Paragraph
says,
12.
I have relied on the decision.
No, Lordship will kindly come to internal page 7.
Yes, I have 7.
Paragraph 12.
No, paragraph 12 says, I have relied on the decision of the Honorable Supreme Court in Amit Bhai Anil Chandra.
That after that, maybe the Lordship will go further. I find force. That is the observation of the court. Amit Bhai's, that judgment is paragraph 12. That
Yes.
further 12.
I think
Another 12.
there is a
Second
yes, yes.
12.
This is at page 10.
Yes, Lord.
Yes.
So 12 has been typed twice. May I read it, Lord? I find force in the argument.
Like, yeah, what happened is that you see, sometimes we have to also depend on the stenographers.
Lord.
Now, it is not possible
Absolutely,
to
Lord. I fully
check
agree.
the numbering of the paragraphs also.
The number of cases and number of orders, Lord.
It's humanly sometimes not possible, you see.
Absolutely.
Anyways,
I find force in the argument of the, in England, what they do, Lordship, in the courts, they dictate the order, a dictaphone takes it, and the orders is given to both the sides to go through it.
that's a
Then
good,
That's immediately it was returned after verifying, after waiting, it was signed, it is signed.
in fact, I did call the IT people to
Okay.
suggest if we can also do something similar.
Yes.
Because initially I was finding difficult because there are not enough stenographers provided to us.
Yes.
So it is very difficult. You see, sometimes the CAV suffer because of that, because they are so busy with the court's work.
True.
And there are times when we are sitting idle and we don't have anyone to dictate. So I was trying to see if something like this can come up. 1 or 2 apps I did try, but again, there a lot of mistakes come. It's not possible. You end up keeping on correcting even the names, places,
True.
everything is
Messed up.
messed up. Yes.
I find force in the argument of the learned senior counsel for the petitioners. At this juncture, it cannot be conclusively decided if this FIR can be segregated from the third FIR or merged with the first FIR, which initially brought allegations of illegality in procurement of tender works and illegal gratification being paid to the several railway officials by paying gratification through bank accounts of their family members and relatives. Entire case has to be scrutinized even to arrive at a conclusion that the present FIR alleged to be the third FIR arising out of the same cause of action relating to the same transaction or transactions. However, there appears to be a prima facie case to grant interim stay at least till the next date. So and so, then for last line, last paragraph, till then no coercive action to be taken against the petitioners and further proceedings of CBI case number so and so
Stayed.
stayed.
Yes.
The next date of listing, that is 20. And on
Yes.
28th, the matter came up. the other side CBI filed a affidavit, it was not on record, and on that day, it was further extended. So my humble submission is that twofold. One is that I would like to give a response to the affidavit which they have filed, which I have a right, Lordship, in my humble submission. And the next is that if we look at paragraph 12, that means Lordship will have to examine the records. So records are not yet being called for.
This court will grant you the time, you file your response.
Lordship,
We'll extend the interim order passed earlier. Records we will see at a later stage.
no difficulty.
Heard Mr. D. Saikia, learned senior counsel, assisted by Mr. K. Gogoi, learned counsel appearing for the petitioners. Also heard M. Kumari, right? M. Kumari, learned standing counsel, CBI. Stop. It appears that, no, as per earlier opportunity, CBI has filed their affidavit in opposition. Has filed
on 29.
has filed their objection on, filed when?
I think
On
19.
Huh?
19.
It was,
Anyway, 19th.
On 20th, it was not in the record. That is the matter was.
On 19th, 6/2025, stop. Since the aforesaid affidavit was not on record on 26/2025, when this matter was last posted, the matter was directed to be posted today along with a copy of the same on record. It appears that the said written objection has been brought on record. Mr. Saikia, so-and-so seeks a short accommodation to file a reply to the aforesaid affidavit. Prayer is allowed when?
In the third week, last week of July, Lordship.
Last week would be a little late.
Can I submit few lines before your lordship? On that day, on 19, we have.
That's all
already
right.
sub-
We are granting
But
the
there
time.
is no
So
provision
maybe
granting
second week of reopening or second week at a date. Released on such and such date. Till then, the interim order passed earlier shall remain in force.
On 23rd or 24th, Lordship. 23rd, deeply obliged, Lordship.
Supplementary list. Number 49.
May I please, Your Worship? This matter relates to custody, Your Worship, of.
Relates to?
Custody of, Your Worship, certain goods. These are coppers and, Your Worship, brass.
Yes, who's appearing for the other side? Scan copy of case records, case diary.
In fact, Your Lordship, there are two orders here, Your Lordship. What has happened, Your Lordship? If Your Lordship comes to page 31, Your Lordship.
Page?
Page 31 of my petition.
Today the matter is come for what? Admission?
And
Page 31.
31, Your Lordship. This is first petition for custody we have filed, Your Lordship.
Yes.
Now, Your Lordship, when this was filed, Your Lordship, in the meantime, certain fresh seizure were made by the investigating agents, Your Lordship. Therefore, what we did, Your Lordship, if Your Lordship comes to page 41, Your Lordship, we file another petition for the custody under section 457. Your Lordship. Now, in that petition, Your Lordship, there is an order passed by this honorable, by the learned trial court, Your Lordship, saying that granting us, Your Lordship, the custody that we will submit the ownership documents and it will be verified and thereafter it will be handed over to us, Your Lordship. Now, in the meanwhile, Your Lordship, charge sheet was submitted and the matter was, Your Lordship, remitted to the session judge, Your Lordship. Now, since it's a session tribal case. Now, that earlier petition was pending, Your Lordship. Learned session judge, Your Lordship, passed an order on in that particular petition rejecting the, Your Lordship, our prayer for custody. Now, two orders are standing. One allowing by the learned CJM, Your Lordship, and another by the learned session judge rejecting our claim, Your Lordship. That's the problem. And Your Lordship, learned session judge, Your Lordship, while passing the order, did not take into consideration report submitted by the investigating agents, Your Lordship. Without considering that, Your Lordship, this order has been passed for rejecting that. Way.
Yes.
Yes,
Report is there or not?
report is not received. Report is not received yet.
Not there.
Not there.
if your lordship comes to page,
I think a report is required.
Report is required, Lordship, but
now your lordship, since it's surseated, your lordship.
charge-sheeted case, Lordship, this is
That's
certificate.
a report.
So, are you ready? Have you gone through it or not?
Not gone through yet, Lordship, right?
So when, tomorrow?
Okay, Lordship, tomorrow.
You have a look at it tomorrow. Relist to me.
Deeply obliged.
May I please, Lordship?
Yes.
Lordship, 528 BNSS Lordship. My Jimma was rejected, Lordship, by the trial court.
What
this
vehicle?
being ordered-
Vehicle?
Yes, Lordship. that
Hmm.
is.
Yes, report,
Report was done.
report,
Report not received yet, Lordship.
last opportunity.
Yes, Lordship.
Awaiting report. Mr. So-and-so learned APP assures that the report as called earlier shall be positively placed before this court by the next date of listing.
Lordship, the last occasion, they said they received the report.
They have sent a report only last occasion, Lordship. It is here, it's first sheet submitted in this case.
So then,
Report is the case diary and all other things is submitted before the trial court, Lordship.
so that has to be called.
That's a call.
Then you say Mr. DP Goswami learned APP for the state respondent submits that as per the instruction received, charge sheet has already been submitted.
Having charge sheet number, Lordship,
Wide charge sheet number
27/23,
27 of
2023,
23
dated 28 to 2023.
dated 2020.
28 to 23. Yes, Lordship.
28 2023.
28 to 23.
28 to 2023. Stop. Let the scan copy of the case records along with case diary
Along with the case diary, Lordship.
be called for through the registry.
I think
Uh,
LCR already received.
No, Mr. Goswami, I'm told the scan copies have already come.
Then Lordship, we have to go through the case record, Lordship.
Reopening then.
Lordship.
Mr. Gos,
Day after tomorrow, Lordship.
it'll be difficult. A lot many matters are fixed tomorrow. 2 days working. First day, but second day,
On
did you?
Friday, Lordship. Possible, Lordship.
All right, we can make an attempt for tomorrow. Relist tomorrow.
Much obliged.
এই দুটা matters দেখুৱাই দিব এইটো আৰু আগৰটো স্ক্যান কপি খিনি দিয়ক চাব দি দিব yes
Item number 4.
yes
May I please, Your Lordship?
mediation what has happened
Your Lordship, yes, Your Lord, can I just forward?
what has happened
Your Lordship, they have
Mediation
Your
was failed,
Lordship.
Lordship.
huh
In here,
Mediation was failed, Lordship.
huh
Mediation was failed, Lordship.
failed
but Your Lordship, they are, the petitioner is trying to make up mutually, Your Lordship.
you need time for
He's trying to make up mutually, Your Lordship. Although it's failed in the family court, the counseling.
we can only give you a last opportunity nothing more
Lordship.
you have already failed the mediation failed
Your Lordship, here I would like to mention a few things, Your Lordship. If Your Lordship.
it's all right we are giving you a last opportunity nothing more it appears that the mediation as directed earlier by this court has failed Stop.
Your Lordship, I just want to point out the cause. The
Find out the
cause of failure, Your
that's all right I'm not going into all that
Worship, may I submit, Worship, in the meantime, Worship, maybe director petitioner clear the area.
no not right now I'm not doing it however MS yes your name
Your Lordship, MSPN.
MSP Ahmed Learned Counsel appearing for the petitioner submits that a last opportunity be given submits that the petitioner is trying to mutually solve the issue and accordingly seeks a short accommodation by way of a last chance list on such and such date reopening
Maybe fixed it.
I'm giving you a date so On that day, we will give necessary directions if you're not sorting it out.
Oblige.
Supplementary list item number 51. Here.
None appears for the petitioner on call relist after vacation date deliver. So and so. Next.
Item 15 and 16. For others.
Fifteen and 16.
Yes, Lordship.
Here, 16 is tagged because 15 you are saying
Yes, Lordship.
15 has become infractious.
Yes.
And who is appearing in 16?
We have not received the paper book.
In 16. Anyway, 50, I think they both were tagged because 155, the record was available in 155, isn't it? Acha, you write in the first one, in item 15. Mr.
S. Islam on behalf of Jadis Ahmed.
Mr. Jed
S. Islam, I'm
S. Islam.
on behalf of
On
Jadis-
behalf of Mr. Jed H. Ahmed, learned counsel appearing for the appellant submits that.
Matter become infractious.
Why infractions the appeal?
Lordship, as instructor from my senior Lordship Jadis Ahmed.
No, Mr. Who is appearing for the state? How has the criminal appeal become infractious? I've not understood why has it become infractious? It's a statutory appeal. Unless, of course, can it become infractious?
Cannot be Lordship.
Cannot become infractious.
Lordship, fix after vacation, Lordship.
You find out what has happened. Did the appellant die?
No,
The
Lordship,
sole appellant.
Actually, we have no any clear.
You have no idea and you're making a submission before the constitutional court and criminal appeal has become infractious. You don't even know why infractious. Please don't stand before this court and make whatever submissions you feel like. Please take responsibility before making a submission before this court.
Lordship, will submit.
Please don't convert these courts into some living room. I strongly deprecate such kind of practices.
Lordship, will-
Is appearing for the respondent number 2.
Yes? You want to say something?
I'm appearing on behalf of patient for respondent number 2. I'm paying for another date.
Praying for? As prayed for list after 2 weeks on a date to be fixed by the registry.
Deep level.
In item 16, you say MS so-and-so, the paper book has not given to you. Submits that the paper book has not been, but is there an order for paper books? Huh? It's a,
Lordship, I have gone to the office now. I have not received.
okay. Submits that she has not been furnished with the paper book. Let registry do the needful.
Deep level.
Item 17.
Please, Your Lordship. Lordship, as per office note, the 17/6/25 notice was issued upon respondent number 2.
Report service POXO.
Also one.
Yes? What happened?
My lord, not received, my lord.
Not received. You find out.
My lord.
Mr. B. Sharma, learned, Mr. B. Sharma, learned APP for the state respondent, submits that, assures that he shall obtain the report from the jurisdictional police station as regards the status of service upon respondent number 2 informant. Relist after 2 weeks on a date to be fixed by the registry.
18.
POXO again.
Yes, my lord. May I please, my lord?
Mr. Nawaz, you are for the informant.
For informant, Amicus, my lord. I am, my lord, I have received the records, my lord. I am able to argue, but I've seen.
You a short date because unless they look into the paper book, how can you argue your suspension? I understand you want your suspension and interim, but
Yes.
to consider that a fair opportunity has to be given to the informant because it's the POXO case, right? If it was not POXO, I would have heard you.
Yes, my lord, in this case, I have filed this appeal in the year 2023 along with a LP, leave petition. Because the method was.
R2? You are R2?
Our senior was appointed as the amicus curiae lordship last time, but the engaged counsel for the respondent number 2 appeared. But our name appears to show in the cause list.
Huh?
Our name still appears to show in the cause list.
Very well, you be there.
Last occasion, my lord, Mr. Datta was appearing as a respondent's advocate.
So what is to be done now? Who's going to appear?
I don't know. On that he said that my Wakalatnama was not
So
absorbed.
right now, Mr. Datta is appearing. You are from, on behalf of,
Oh. Now who will appear? It will be decided.
this is item number
20, my lord.
20. T theory has been. But in such situations, amicus are always welcome, but if you are not willing, we will struck off your name. And this matter otherwise is ready for hearing.
No, no, my lord. There is a question, my lord. Question of law, my lord.
All.
Yes.
So
my
that
lord.
has to be heard.
Yes, my lord, regarding the LP, my lord.
Okay,
leave
then I'll
petition.
post it for after the vacation. Heard MS NS Thakuria, Lord Counsel appearing for the appellant. Stop. Mr.
You Bharadwaj.
U. Bharadwaj submits that though the engaged, respondent number 2's engaged counsel, Mr. N.J. Datta, is appearing for on behalf of respondent number 2. No, don't say though, since the amicus curiae, Mr. T. Deori, on whose behalf he has made the submission, may kindly be excused. Prayer is allowed. Let the name of Mr. T. Deori as an amicus curiae be not reflected any longer in the cause list. Relist on a date, did you? When? On such and such date.
Deeply obliged.
And then, Mr. Counsel, your name?
Obliged.
M. Datta. M. Raman. M. Raman is present on behalf of Mr. N.J. Datta, huh? For respondent number 2.
Deeply obliged.
Item 21.
Lord, there is an IA melodies.
IA.
Milord.
IA for?
IA for implementing, Milord, opposite party number.
IA for?
Implement.
Implement.
Of-
Where's the IA?
Because during pendency of the petition, Milord, the respondent number 2 died, Milord.
Respondent number?
2,
2 died.
my lord. Therefore,
Legal hai?
Legal here.
The notice has to go.
Yes, Milord.
Issue notice. Returnable 2 weeks, registered post AD. In the IA, huh? And list after so and so on a date to be fixed by the registry. In the criminal revision petition, you may simply say, in view of the order passed in IA, list on such and such.
I'm obliged.
Item 22.
Wait, please, your lordship.
Yes.
The last date, the PP was,
Take instruction whether communicated document instruction awaited. So we take instruction again.
Await instruction, list on such and such date, relist on such and such date.
Item 23.
POXO.
Lordship, yes, conviction lordship under section 10 of POXO Act. Well, so far.
Who is appearing for the informant?
Notice is concerned lordship.
Notice for sub yet, we have to wait.
Yes.
State for orders, the matter is listed for orders for service upon the respondent number 2 lordship.
Respondent number?
Lordship.
What has happened?
Before that, Lordship, a small prayer, Lordship, we have challenged the.
No, but it says no such person in this address.
Yes, Lordship. I may be allowed to Dosti service, Lordship.
Ah,
I may be allowed to take Dosti service in this.
no, you take Dusty, but if,
The respondent number 2 already.
take fresh service, because if you know the address and also Dusty,
Lordship.
Mr. Bora, na?
Another prayer, Lordship, in this case, my prayer, Lordship, I have challenged the also execution petition, which is.
Nothing, first get the notice served. You're Mr. K. Borwa,
ABT Hawk.
huh?
ABT Hawk.
Sorry?
ABT Hawk.
Or ABT Hawk. Mr. ABT Hawk, Learned Counsel appearing for the petitioner seeks submits that he may be allowed to take fresh steps as well as by Dusty in respect of respondent number 2.
One prayer, Lordship.
Prayer is allowed, released after 2 weeks on a date to be fixed by the registry.
I may be allowed one small prayer, Lordship. Execution petition is fixed on next 38, Lordship, just.
Yes, next.
Is a bench to patient. Lordship.
Yes, Mr. Vaidya.
Lordship, this is a criminal petition with regard to an NIAC matter, my lord. The petitioners had taken steps, and my lord, I am entering appearance on behalf of the respondent number 3 and 4, my lord.
First time.
First time, my lord.
You want some time?
Yes, my lord. Come for orders, my lord. After the vacation, matter may come up for admission, my lord.
Heard MS?
P. Das, Lordship.
P. Das, Learned Counsel appearing for the petitioner. Stop. Also heard Mr. D. Vaidya, Learned Counsel appearing for
Respondents number 3 and 4.
respondent number 3 and 4, and Mr. Bharadwaj for respondent number 1. And state is also there? No.
Stated.
Stop. In view of the appearance of the Learned Counsels on behalf of the respondents, service stands complete. List for admission. Yes, date. Do you want date?
My lord, anytime
After 3 weeks and a date to be fixed by the registry.
That's
26.
May I please your lordship? So in this case, up to that case, there was called for along with
We
the
have received a case just now, so we have to go through it, Lordship.
And when?
Immediately after vacation, Lordship.
and lordship, earlier medical report was also called for.
Medical has come or not?
Verify on the.
Verify. Heard MS?
P. Soria.
P. Sohoria, Learned Counsel for the petitioner. Also heard Mr. D.P. Goswami, Learned APP for the state respondent. Mr. Goswami submits that the updated case diary along with the medico-legal report as report from the GMCH as called earlier has been received. However, seeks a short accommodation to go through the same. Has been received today, has been received today, and accordingly seeks a short accommodation to go through the same. Prayer is allowed, released on immediately after vacation on such and such date. Date to date, yeah. Interim, if any, shall continue till the next date of listing.
27.
138, leave petition. Notice not issued. Issue notice?
Yes.
Issue notice, returnable 3 weeks. How many respondents?
3.
Steps by registered post AD within 3 days. List after 3 weeks on a date to be fixed by the registry.
28.
May I please, Lordship?
Leave petition.
Lordship.
IA, what is the IA? Oh,
Lordship,
yes.
we have filed this leave petition.
Notice,
Yes, your lordship.
same, huh? Notice, steps by registered post AD, 3 weeks, list after 3 weeks.
Lordship.
29.
Same. Notice,
Senior counsel is in port number 9.
I'm issuing notice, you don't want notice, then I will post it after vacation. Huh? What more can I do today? Can your senior seek something more today before the notice? Then, what's your name?
Anthony.
Heard, Mr.
Anthony.
G. Ahmed.
Anthony.
Anthony, learned counsel for the petitioner. In this order, I am recording your name. Issue notice, steps by Register Sport AD, 3 weeks.
Item 31.
30. Keyhole. Huh? Ms. Bora, wait, some problem in 30. Find out what is the problem.
May I please?
Huh? Brief not found.
May I please? Worship, on the last occasion, service report was provided, Worship.
Report. Yes, Mr. Goswami, report POXO matter.
Not to see better, we have to take instructions.
Why are these reports in POXO matters not being sent by the jurisdictional police station? Why should even a reminder be sent?
Not to- we have communicated many times.
No, if you have communicated many times, then I shall ensure that he is present on the next date.
Okay.
This cannot go on like this. Isn't it, Mr. Sharma? They must immediately be prompt in sending the report. Because without knowing what has happened, now this court also cannot proceed.
Last time, I will personally communicate it.
But do you look after it? In fact, when these matters are posted, kindly try and see if you can, sometime even they send you in WhatsApp and you can let us know if after receiving nobody is appearing, this court can always appoint amicus curiae or legal aid counsels to represent the informant. These appeals has to go on, right? These are statutory appeals. Mr. D.P. Goswami, learned APP, assures that the report of service in respect of respondent number 2 shall be obtained from the jurisdictional police station and be positively placed before this court by the next date of listing. List on such and such date.
Obliged.
Item 30.
Yes, Ms. Bora?
Here I am appearing for respondent number 2, Lordship, protection officer. I need some time to contact with him.
You are the informant.
Yes, Lordship.
First time appearing?
Yes.
After notice, all right.
Yesterday I have received a bill.
MS R. Bora,
RB Bora.
RB Bora, learned
Legal aid counsel.
legal aid counsels enter appearance on behalf of the respondent number 2 and seeks a short accommodation to
Contact with the.
don't say that, and seeks a short accommodation in the matter. Prayer is allowed. List for the IA is for what? For suspension?
Suspension of sentence.
Then I will say, I'm not giving you much time.
I copy of the IA is not received by me.
You give a copy. She further, then you say RS Bora submits that a copy of the IA has not been furnished. Let a copy of the same be furnished. List on date on such and such date for consideration of the prayer made in the interlocutory application.
It's possible on 27th, Your Lordship.
27?
Yes. Deep.
27th of this month, Your Lordship.
Huh? Oh, no, not Friday. Reopening.
Reopening.
Are you, would you be able to?
Friday, no,
Ah.
immediately after vacation.
Yes. All right.
On 15th, Your Lordship.
Deeply.
Deeply obliged, Your Lordship.
I don't have the clue.
May it please your lordship.
Yes.
Your lordship, the service. upon the-
87 days.
Yes, your lordship. The service upon the respondent number 2 is complete.
Complete.
Yes, your lordship.
Your name?
MK Brown.
Heard MSN
MK Brown.
K Brahma.
Brown. BROWN.
Brown. I'm Kim Brown, learned counsel appearing for the petitioner. I'm sorry, I'm not being able to hear better because I don't know, there is some sound from here coming. It doesn't appear of I think some machine there. What is that machine? Huh? That is for a sound and that is only obstructing the sound. It fix korbo dibo. Office note dated 11/4/2025 indicate that service in respect of respondent number 2 has been completed. However, none appears on call. And Mr. Goswami, so and so, is present for respondent number 1. I'm allowing it. Any objection?
Yes, your lordship. May it please your lordship. The service upon the respondent number 2 is complete.
Yes, by way of this petition under section application, by way of this application under section 5, Ms. Brown, please take your seat. By way of this application under section 5 of the Limitation Act 1963, the applicant is seeking condonation of delay of 87 days in filing the accompanying criminal appeal under section 4152 of the BNSS 2023. Stop. The brief facts of the case is that the learned Special Judge Poxo Golaghat in Special Poxo case number 50/2021, after hearing the arguments of both the sides, rendered its judgment and order on 30/9/2024, whereby the appellant was convicted and sentenced to undergo SI of 3 years and a fine of rupees 5,000. In default, SI of another 15 days under section 363 IPC, and to undergo RI of 20 years and fine of rupees 10,000. In default, SI of another 1 month under section 6 POXO Act. Stop. However, being aggrieved and dissatisfied, the accompanying criminal appeal was filed. However, while filing the criminal appeal, there has been a delay of 87 days. Accordingly, the instant condonation application has been filed. Stop. MS Brown, so-and-so, learned counsel for the applicant submits that the delay has been unintentional and the grounds urged in the condonation application are sufficient for condoning the delay. Stop. Mr. So-and-so, learned state counsel, does not oppose to the condonation prayer. Stop. Heard, perused. Relevant paragraphs of the condonation application reads as under, quote unquote, paragraph 4 to paragraph 6. Page 4 it starts. Reading of the aforesaid paragraphs, it appears that the grounds urged are sufficient and bona fide, and accordingly, the delay of 87 days is condoned. Condonation application stands allowed. Is the criminal appeal registered?
No, Your Lordship.
Let the criminal appeal be registered and placed before the court.
Obliged.
None appears for the applicant on call released after 2 weeks on a date to be fixed by the registry.
Aye.
22 days. Notice served or first time?
First time.
Notice. No status there. What is the ground of delay?
Your Lordship, she is a poor lady. His financial condition is not.
Mr. Counsel. The ground is there. Yes.
22 days delay.
Heard, Mr. G. Borgwai. Gwari, learned counsel appearing for the applicant. Stop. In naam khini didi bole to. Also heard Mr. DP Goswami, learned APP for the state respondent. By way of this application, the applicant is seeking condoning of the delay of 22 days in filing the criminal revision petition challenging the impugned order dated 30/1/2025 passed in PRC number 50 of 2020 by the learned Chief Judicial Magistrate Borpeta. Stop. The brief facts of the case is that non-bailable warrant of arrest has been issued against the applicant in PRC case number 50 of 2020 on 31/2025 by the learned Chief Judicial Magistrate Borpeta. However, aggrieved by the aforesaid order, the petitioner, the applicant has filed the accompanying criminal revision petition. However, while filing the same, there has been a delay of 22 days. Accordingly, the instant condonation application. Stop. Mr. Gayari, learned counsel for the applicant submits that the applicant being a being a lady from the financially weaker section, and due to her financial condition, she could not approach a lawyer, and therefore the delay of 22 days had occurred. Stop. Mr. So-and-so, learned APP, submits that he has received no instruction to oppose to the condonation prayer made in the instant condonation application. Heard, perused. The grounds of condonation of delay as averred in the condonation application reads as under paragraph 2, 3, 4. Quote unquote, page 2. Reading of the aforesaid paragraphs, it appears that the grounds urged for condoning the delay are sufficient and bona fide. Accordingly, the delay of 22 days in filing the accompanying criminal revision petition stands condoned. Let registry register the accompanying criminal revision petition. Disposed of. None appears for the petitioner on call, released after 2 weeks on a date to be fixed by the registry.
May I please, your lordship?
Yes.
On behalf of the sole respondent here. The vocal number already will
Filed.
There is
Notice is complete.
scan copy has been called for, my lord. Scan copy also been called.
Scan copy to ahane.
There is the interim order, my lord.
Earlier, I think requisition of scan copy is done, but it has not come. Though office note dated, Though office note dated 11/6/2025 indicates that notice in respect of respondent number 1 has not been, you are for
Sole respondent.
1
Yes, sir.
has
Sole
not,
respondent here.
has issued. However, today on call, Mr.
Muhammad A. Islam.
M.
A. Islam. Muhammad A. Islam.
Mr. A. Islam enters appearance on behalf of the sole respondent. Accordingly, service in respect of the respondent stands complete. It further appears that the legible scan copy of the records of complaint case number 596C/2024 from the Court of Learned Judicial Magistrate First Class Kamrup Metro Guwahati as called earlier is still awaited. Relist and issue reminder, relist after 3 weeks on a date to be fixed by the registry. Interim, if any, shall continue till the next date of listing.
Lordship, on the next date, I will file the affidavit in opposition.
You file whatever you are entitled to file. You don't need a liberty from this court. If you're entitled in law, you file. Yes, next.
May it please your lordships. Lordship, there is a delay of 710 days in preferring the appeal against the judgment and order date.
Notice is not gone.
Notice has not yet been.
All right, issue notice. You are any private respondent?
Yes, lordship, there is a private response.
Mr. Goswami accepts notice on behalf of R1, registered post AD in respect of R2, list after 3 weeks.
Lordship, there is some typographical error in the application. I may be permitted to correct it.
No, I think nowadays there are some restrictions. So
That
please
is the
consult with the
consequence.
Jaji Parrot, Itya Dibon, or the registry.
Obliged.
You check.
Yes, lordship.
Item 39.
Need, please, your lordship. I is for delay.
Change Koroktok. Why are you not changing her? 1 second. You type out the disposals. Madam. ইফালে আহিব দিয়ক। Yes,
Lordship is, IA is for condonation of.
notice has not gone.
Not done.
Private respondent is there.
Yes, my.
Mashwa, this is condonation application. Issue notice, Mr. B. Sharma, learned APP for the state respondent accepts notice on behalf of R1, steps by registered post AD in respect of R2, list after 3 weeks on a date to be fixed by the registry.
Oblige, lordship.
12 days.
Yes.
Private respondent is there.
Yes, lordship.
Same, notice. Mr. B. Sharma for 1 and registered post for R2 and 3. Huh? No, but this is a POXO matter.
Yes, lordship.
POXO. So then I think for R3, in terms of Deepak Nayak, informant and, isn't it?
My lord, respond number 2, my lord, it is informant.
Three, lordship.
Who's the informant?
Yes.
Informant, lordship, respondent number 2 and 3 victim.
No, informant is who? Is the mother, father, guardian, support person?
Others.
Huh?
Others.
Sorry?
Lordship, unknown person.
Another person.
Another person.
So registered post AD for R2 and for R3 in terms of Deepak Nayak. 3 weeks.
Service is awaited, let's say,
Await service, list after 3 weeks on a date to be fixed by the registry. 29 days. First time. A private respondent? Private?
Sole respondent.
No, sole is a private.
Private.
Issue notice, returnable 3 weeks, registered post AD. Yes. 102 days delay. First time.
Notice may go, my lord.
Huh?
Notice may be issued, my lord.
No, that's right. That's why I ask you first time. As private respondent, how many?
One informant.
Okay. Notice, Mr. B. Sharma accepts for R1 extra copies and for R2 registered for AD within 3 days, 3 weeks.
Highly obliged.
First time?
Yes.
Private respondent?
Private respondent, respondent number.
Okay.
State.
Notice B. Sharma for R1 registered post AD R2, 3 weeks.
Please, your lordship. Connecting.
First time? Private respondent is there? Thing. এখন আমরা এফএলএ করে দেখি।
We have filed the amended cost settlement.
Yeah.
It's attached to Lordship's record.
Yes, Mr. Barua?
Yes, my lord, I have got two submission, my lord.
Yes.
My lord, since the matter is searched, my lord, because my lord, searched means my lord, investigation has been done, my lord, material has been found, my lord. After that, my lord, the investigating officer has submitted searched, my lord. Now, my lord, Lordship may kindly come to my lord, page number 64, my lord.
64.
64, my lord. This is a search sheet, my lord, original search sheet, my lord. Vernacular.
The charge sheet is okay, but you see, mere breach of trust is not criminal breach of trust.
Why am
To attract breach of criminal breach of trust, the criminality has to be there.
why am
Undoubtedly, there has been some breach.
yes.
Security deposit has not been returned. There must be some breach. You have referred to that condition also yesterday.
Yes.
But that itself is not sufficient to attract a criminal offense.
Yes, no, my lord.
Anyway, 60,
And the 64, my lord, page number 64. Why I am relying, my lord, that is why I am submitting.
all right, let us see.
No, page number 64, my lord.
Yes.
The vernacular, my lord, Lordship may kindly see the date, my lord.
What is the date?
23/12/2021 searches submitted, my lord.
23,
12.
12/21.
21, my lord. The searches submitted, my lord, that means, my lord, in the year 2021, investigation has been completed, my lord. Thereafter, my lord, Lordship may kindly come to page number 85, my lord.
23, 12, 20. Yes. Page number?
85, my lord. Annexer 6.
Yes.
My lord, see there, my lord, order dated 29/5/2023, my lord. And my lord, I am not reading the entire, my lord.
Yes.
My lord, considering the, my lord, that ordered, third, fourth paragraph, my lord. Considering.
Charges have been
and
framed.
based on record, I am of the opinion that there is a ground to presume that the accused person have committed offence under section 406, 506 IPC. Accordingly, charges have been framed against the accused person under the above.
This order is under challenge.
Yes, my lord. Now, my lord, Lordship may kindly see the date, my lord.
Huh?
Date, Lordship may kindly see.
23.
29/5/2023. My lord, almost 2 years back, my lord, charges framed, my lord. That is, my lord, trial commence. Now, my lord, after 2 years, they have come, my lord, before this honorable.
What is the
court.
status of the trial? You
My
don't know.
evidence is going on, my lord. My learned friend, my lord, I have inquired from my learned friend. He has said, my lord, EW1 is completed, but cross-examination part is there, my lord.
EW.
Why so much delay, Mr. Gautam?
I'll submit.
These are my submissions, my lord, because, my lord, this is the matter.
You see, Mr. Gautam, definitely you will be getting notice. This court was giving you so much because this court was considering of staying. But the fact that you have come after so long itself goes against for an interim order today.
Most certainly.
At best, I can issue an notice on the interim also. But I'm not going to stay the proceeding today. Let the other side appear.
Milord, if I may.
Because
submit-
you see, 23 charges, 21 charge sheet was filed, charges framed in 2023. We are in 25.
Yes, ma'am.
Why? Now, last 2 years, my lord, they are not agreed by the investigation because they are very much aware, my lord. The investigation has been completed, charges submitted, even the trial court has framed charges, my lord.
But that also will not mean that if tomorrow this court finds that the materials are not sufficient, this court can always look into it. Now, today I am not hearing the petition. All I am considering is whether the interim should be considered or not at this stage. I think that is the only thing you are interested today. So, you see, staying of the further proceedings, had you moved earlier? Certainly.
With Milord's permission, Milord, if I may only submit for a moment. Milord, my learned senior, Milord, is absolutely correct. Milord. In fact, EW2 has been examined in chief. EW2's cross-examination is going on. It's still underway, Milord. The issue is, Milord, that at the time when the charges was filed, and he has not disputed it, we cannot bring before the trial court, Milord, that a civil suit has been filed. By the time the charges were framed, the civil suit was already filed. We had filed a WS as well. We could not bring that, Milord, because of Devendranath Padhi. The Honorable Supreme Court has clarified that defense material cannot be considered. What has happened is...
One water?
No, Milord. I'm just having a little bit of a cold. Just having a little bit of a cold, Milord, but I'm all right. What has happened is, Milord, this year, in April 2025, the cross-examination in the civil suit began. And the composite matter that I have brought before your lordship here is predicated on three foundations. There are three things in the FIR minutes, if I may submit. There are three things. First, they are saying that we have paid 13,60,000 as an advance money. That ought to have been returned to us. Second,
Mr. Gautam,
yes,
I'm not going to stay the further proceedings today. I'm going to issue notice on the interim.
well,
I'll
the
have a
fixed date,
bit on
July,
reopening.
yes, July or
Yes,
first week of August, my lord.
Otherwise, you see, reading by the FIR yesterday, and also that condition which you showed, I was quite inclined to stay the proceedings, but now the facts, you
Yeah,
see,
then. But
this is
the
going
only
against.
reason why-
Anyway, heard Mr. A. Gautam, learned counsel appearing for the petitioner, also heard Mr. R.J. Barwa, learned APP for the state respondent. Stop. Issue notice, returnable date of the deed after reopening.
First week of August.
Okay, give a date in the first week of August. Mr. R.J. Barwa accepts notice on behalf of respondent number 1, registered post AD as well as Dusty.
Yes, ma'am.
In respect of respondent number 2, interim prayer made shall be, interim prayer is kept open for consideration after the service is effectuated on the next date. Lists accordingly.
Grateful.
Mr. Gautam, now that the matters are over, my recollection of this courtroom is when your grandfather was this side. That is the time